Ladies and gentlemen, hit subscribe to this channel right now. This is the latest article in the New York Sun on the Supreme Court and the presidential constitutional immunity victory that Trump is going to get, that I have predicted for months and months on this channel. I told you there would be a unanimous Supreme Court victory for Trump, overturning the Colorado State Supreme Court. Even the liberal justices sided with Trump. It was a 9-0 unanimous decision overturning a very absurd, unconstitutional ban. They tried to ban Trump nationally. This is a New York Sun article. Jack Smith and Donald Trump brace for Supreme Court's rule of the ages. Rule for the ages. The justices could throw the special counsel's prosecution off track. They will do so. He will get a huge, monumental, historic victory on presidential immunity. They'll give him partial immunity. That's all he needs is partial immunity, ladies and gentlemen. So he'll get partial immunity, and in addition to partial immunity, which will completely derail the special counsel case against him, the special counsel will then be dissolved. Once he wins, because he'll win in November, the special counsel will be dissolved. Could be a landslide. I think it's going to be a landslide Trump victory. But the special counsel will be dissolved, especially after the immunity victory. Okay, he's allowed to perform a speech as president. He didn't incite or compel or tell anyone to commit a crime. That is a blatant lie by anyone who tells you that. He literally told people to go peacefully and patriotically. But hit subscribe to this channel. The unconstitutional guilty verdict will be overturned. It'll be overturned. It's almost certainly already overturned in the minds. Well, the conservative Supreme Court justices, they will vote against the absurd, unconstitutional guilty verdict. So that's a done deal in my book. It's just a matter of when it gets to the Supreme Court. Everybody here loved trucks. Kathy, Richard, Arturo. I actually, in the comments section, this is the first time I only allowed members to comment. So we'll see how it goes. Maybe, because I always just allow anyone to comment, and it works out perfectly. But today it's just members, subscribers. So hit subscribe if you do want to comment on this live stream, and just hit subscribe in general. Let's get to Mark Levin. Very, very, very intelligent legal scholar, constitutional scholar. He's going to explain exactly why the Supreme Court will get involved. I'm telling you, ladies and gentlemen, this month is Supreme Court month. We're waiting for, number one, the immunity victory, the constitutional presidential immunity victory. They're trying to say that Trump wasn't president when he performed a speech. They're trying to say that he had no right to speak to political allies in different states to contest results. He had a right to do everything that he did. That's why they waited for 4 years. See, the difference between Hunter and Trump is that Hunter's crime is a legitimate, obvious, overt, blatant crime. With Trump, they had to elevate state misdemeanors, okay? They didn't elevate state misdemeanors with Hunter. They were federal crimes to begin with. With Trump, they elevated state misdemeanors into felonies with a non-existent federal statute. There's literally no federal statute that the court in New York leveled against Trump. That makes it unconstitutional. The federal government, the FEC, and the Department of Justice literally did not level a statute against Trump. We don't know which statute in the FEC that they're citing. That is blatantly unconstitutional. That's why this channel is growing, and I'm going to focus on this every single day, ladies and gentlemen. I'll do so tonight at 10 p.m. Eastern as well. Hit subscribe. Let's listen to the great Mark Levin.
These are federal law, federal constitutional violations, federal jurisdictional violations by an acting state judge and a prosecutor, by two people. And it's ongoing. Sentencing and other issues have to be decided by the local judge, and then the appellate level, and then the level after that. This is an ongoing violation. It doesn't even matter what the final court has to say. Again, if I'm Donald Trump's lawyers, I go through that process, but you go to the Supreme Court of the United States. Now, how do we get to the Supreme Court of the United States? This is where people get bogged down. There are writs at common law. And it really doesn't matter which writ you follow. Here's a piece by former Attorney General Griffin Bell. He would later become Attorney General under Jimmy Carter. In the Southern Methodist University Law School Law Review, the federal appellate courts and all writs. And it discusses what these common law writs are. Now, it discusses it in the context of a specific statute, the All Writs Act, that was passed as part of the original Judiciary Act in 1789. Not to get into the weeds, we're smart, we can follow this. The peremptory common law writs are among the most potent weapons in the judicial arsenal. These common law writs are used. They're rare, but they're used more and more within the federal chain of courts.
Get your free copy of my new
Ladies and gentlemen, Trump must put it on the writs. I don't know why I had to say that. I know it's terrible. Let's continue.
Does he say here? Well, the basis for general judicial supervision over inferior courts, inferior federal courts, through extraordinary or preemptory writs can be found in early common law. The All Writs Act is a direct descendant of the Judiciary Act of 1789, other than the Supreme Court, which is created by the Constitution. Everything else is created by Congress. All the other courts, the number of courts, how many justices are on the Supreme Court. It granted federal courts the power to issue extraordinary writs in aid of their respective jurisdictions. And while it is clear that the All Writs Act authorizes the issuance of the traditional common law writs of mandamus and prohibitions, the phrase all writs also encompasses common law certiorari, injunctions, subpoenas. Don't worry about all that. What that really means is there's many ways of characterizing this direct appeal to the Supreme Court and relaying the facts and relaying what's taken place under the law to the court. In fact, you can use multiple requests for writs. It says choosing the correct writ to obtain the desired relief is no longer necessary in the federal courts. Different writs may be sought alternatively or cumulatively. The choice is now unimportant. The subtle distinctions among the various writs have no effect on their relative usefulness as vehicles for interlocutory review. We're not seeking interlocutory review at the federal level, but in effect we are of the state court's activities. Hello, before you finish on the state side, we have some big questions that the Supreme Court needs to answer. The jurisdictional prerequisite for application of the All Writs Act is simply that the writ be necessary, appropriate, in aid of the jurisdiction of the issuing court. The Supreme Court in Levin versus Howes-Letper Company explained the power of the courts of appeals under the Act. Quote, the question of naked power has long been settled by this court. Since the Court of Appeals could at some stage of the proceedings entertain appeals in these cases, it is power in proper circumstances to issue writs of mandamus reaching them. This is an expression of prospective or concurrent appellate jurisdiction. The power of the courts of appeals to issue writs is not limited to cases where an appeal has already been filed. Rather, this power of review extends to all proceedings where the actions of the trial judge at some future stage of the litigation may be reviewable. That applies to the federal chain. But as I explained here, we have violations of federal law, of federal constitutional provisions by a state court. Now, does the Supreme Court, does the federal government ever get involved in state court decisions or state law decisions or state regulatory decisions? You better believe it.
The state in this case had no right to level a federal charge against Trump. That is contrary to our system of government. You need basic, a cursory knowledge of civics, my God almighty. And everyone knows that something is fishy here. You know, and the interesting thing is, people take it for granted that the court had the right to level an FEC crime against Trump. The problem is they didn't. They cannot level a federal charge without the Department of Justice getting involved. The Department of Justice and the Federal Election Commission dropped the case. That's why they have to file a writ, an appropriate one, Trump has to put it on the Ritz. I'm sorry. And he has to get to the Supreme Court ASAP, like yesterday, as soon as possible. As soon as possible. By the way, did I not tell you that the greatest adversary, the greatest political enemy and adversary of Democrats will be the Supreme Court? That's why I've been focusing on the most important, ladies and gentlemen, decisions, news stories this month will be presidential immunity. Democrats are going to make the president more powerful, which is hilarious. Only they can fall upwards like they usually do and fail and then try to make something out of it that benefits them politically. They're going to actually bolster presidential power and authority with their absurd leaps of logic trying to imprison Trump for not having broken any laws. He was protected under the Constitution to perform a speech and to contest results through legal means, which is what he did. My God. So the Supreme Court this month, and also they will overturn the absurd guilty verdict, especially if he gets a jail sentence. So, and they want to jail Trump, so they better do this before July 11th.
There are things called express federal preemption, which is what we have here. Federal Constitution, federal due process rights, federal equal protection rights under the Constitution as applies to the states. Federal jurisdiction under the federal election law, under a federal presidential election, and I could go on and on and on. You have implied federal preemption. You have states that are obstructing federal preemption. You have all this litigation of precedential activity that's taken place before that gives the Supreme Court jurisdiction. A state cannot regulate Congress, which is what it's doing in that court when it takes over authority for determining what a federal election violation is. That's important. Or the Equal Protection Clause, or the Due Process Clause, or the First Amendment Free Speech Clause about a non-disclosure agreement. Federal courts, starting with the Supreme Court, have intervened in state actions before. Civil rights issues, death penalty issues, Bush versus Gore, a presidential election issue, where you have federal jurisdiction issues. And how have they used it? Well, the Supremacy Clause, they've used the Commerce Clause, they've used the Necessary and Proper Clause. When it comes to regulating federal elections, especially a presidential election, Congress has exclusive plenary power. And the Supreme Court has overall authority. When you have an extraordinary, radical, extreme, multitudinous case of violations of federal law, whether it's substantive, whether it's process, whether it's jurisdiction. This is the case. Me, as I said first out of the gate, I'd file common law writs. I'd file a writ of prohibition that restrains a body exercising public power from exceeding its powers or usurping jurisdiction, which it does not have. It seems like this. You could file a writ of mandamus, ordering a lower court, in this case, the state courts, to stay their actions while the court considers. It might go with a writ of certiorari, arguing that there is a statutory basis for it. It doesn't matter. You've got to take it to the door of the Supreme Court. They will decide whether to take it or not. And if they don't, shame on them. Because if there was ever a basis for what we call a common law writ, it's this. And if they don't take it in the Trump case, they're going to have to take it in the future, because these dark blue states are not going to stop unless they're stopped.
So if you can, I'm not joking, you had AOC and I think Durbin or somebody else, some other Democrat, call the Supreme Court, accuse the Supreme Court of helping or of pushing the United States into an authoritarian situation. Okay. Not only is that the antithesis of what's taking place, but the Supreme Court is the only thing preventing us from an authoritarian, wonderful, highly educated, morally superior, liberal establishment dominance of politics. If they had their way, they would have banned Trump already. If they had their way, they would have banned Trump. Think of how stupid that is. Think of how, like, ignorant you'd have to be of this, of just basic knowledge of the Constitution, a cursory glance or knowledge of the Constitution. For anyone, much less a state Supreme Court justice, to think that it's okay to ban a candidate because you feel, through wonderful, morally superior, highly educated liberal sensibilities, that Trump fomented a rebellion. Nobody believes that. They keep on regurgitating the same nonsense. Nobody believes any of it. Nobody believes that Trump was a Kremlin operative, because he wasn't. Categorically, patently false lie and hoax. Nobody believes he tried to foment a rebellion. Even the Supreme Court doesn't. Nobody believes the nonsense from Democrats. That's why they need every single possible advantage, my God almighty. If they didn't have all of Hollywood, virtually all of media, social media algorithms, they really wouldn't win any presidential contest. They wouldn't get the popular vote. The popular vote, for example, is a function only of overwhelming media support. That's it. Okay, if Trump or any Republican got like 24/7, well, maybe not any Republican, but if Trump got 24/7 positive media coverage the way Biden does, and the only negative media coverage is because he's actually doing a bad job. But media, they all voted for Biden. Like they've been propping him up until recently, because they know it's like a complete catastrophe. His presidency is a complete catastrophe. But anyway, let's continue. This is John Yoo, former Attorney General, talking about how, just like Mark Levin stated, you cannot have a federal charge leveled by a state.
Thanks for having me back. I am saddened at what this case has now done to our political and constitutional system. It's hard to exaggerate the harm that it's going to do, not just to Donald Trump. He's important, but the more important question is, what does this do to our institutions? As you said, our legal system, our electoral system, our system of federalism, and the separation of powers for all future presidents, for all future citizens. First, we have never prosecuted a former president before. This was not because past presidents hadn't done anything bad. It's because we thought it was the best thing for our separation of powers to leave presidents alone. And the reason why is because the Constitution concentrates so much responsibility and authority in the president to take care that the laws are faithfully executed, to protect the country from foreign threats, that we don't want our presidents, when they're making the hardest decisions on behalf of the country, to be worrying about whether they're going to be prosecuted or not. We don't want our presidents to be insurance claims adjusters worrying about risks and balances of their own personal finances and their own personal legal situation. We want them to decide what's best for the country. Now, because this case was so frivolous, because it was based on such concocted legal theories, it opens the door wide now for any DA, and there are 2,500 of them in the country, any DA to sue and prosecute any president, any past president, perhaps any sitting president, under the theories that were put forward earlier. I think an even worse problem is for the rule of law. Because what we've all learned now, I think, is that prosecutors can destroy a person. They can destroy a person's reputation, his finances, just by investigating them, even before they get to court, just by.
That's why you do business with Democrats. That's why Hunter's laptop and the foundation of the wonderful former president and first lady and secretary of state, that's why when you do business with Democrats, you coincidentally don't get investigated. That's one perk of doing business. That's one reason why the bribery and graft doesn't come with a piece of paper saying, we are going to give money to Hunter and Joe, and we are going to give you our intentions and sign a letter of intent on this laptop to give money and then receive beneficial treatment. Signed, people who want to influence Democrats. That doesn't happen. Okay, and then media says, where's the evidence? It's like, well, there's 50 intel officials that wanted Hunter's laptop hidden from the public. Gee, I wonder why. Maybe it's because of one email that the New York Post literally published 4 years ago, asking for influence. How can you use your influence on the company's behalf? And still people say, well, I don't see any evidence of anything.
By publicly announcing that they're investigating someone, we have for 230 years relied on prosecutors, on our elected chief executives, governors, and presidents to show, again, statesmanship, to go show good judgment, not to abuse this power. But now what we've seen is that I think the Biden Justice Department and these blue city DAs are abusing this power, not to try to stop crime, but to target individuals because they don't like them, because they're unpopular, and then to find the crimes to fit the man.
If you walk around in New York or Los Angeles or San Francisco or Oakland or Portland or Seattle at night, do you feel safe? I don't know. I've never been at all those locations at one time. Nobody has. But, I mean, if you live there, do you feel safe? If you're in a Chicago, any major Democratic Party run city, Detroit, any Los Angeles, any city at night, do you feel safe? Okay, but you better believe that the number one focus of officials in New York is getting Trump, not making sure that people feel safe walking in. Then they lie through their teeth. The aggregate crime is down, but assaults are up. So, and that's what makes people feel less safe when they're walking down the street and they say to themselves, hey, that individual, talking to, the air, nobody around, yelling, gee, you know what? I don't feel that. And the Democrats don't care. It's like completely like they don't even care. Even Kathy Hochul stated, what was it to Lee Zeldin? Why do you care so much about crime? Something like that. It was like the most typical response by a morally superior liberal Democrat. They don't live in the same world that the average American lives in, where the average American has to focus on inflation, pay more for groceries. They don't care. They're all rich. Okay, the Democrats who pontificate the most about the average working class are the richest, most wealthiest people. And they don't care. They don't have to deal with inflation. They don't have to walk the streets at night. They don't have to, they don't care. So what does it matter to them if interest rates, they're not worried about, buying a new house. They have a mansion. Okay, they get a book deal. These Democratic politicians make money from politics. Trump didn't. Trump lost money from politics. Another reason you should vote for Trump.
That is directly a direct assault on the rule of law. And that harms all of us in the country, all the citizens, not just Trump, not just presidents, but you and me and everyone else.
And what about the electoral system when you have one of these DAs deciding that they get to decide or try to decide the outcome of an election through the process? They can make a ambiguous reference to federal law, seize jurisdiction from what is a complex layer of federal authorities and decision makers.
An ambiguous reference to federal law. That's exactly, perfectly stated by Mark Levin. That's why I'm focusing on this so much. The channel is growing. People love the live streams. It's because this is the most blatant, most egregious, most overt, unconstitutional, really crime that's been leveled against Trump. He's accused of a crime, but it's really a crime that was done, that it's done to him. This is blatantly unconstitutional. They were so desperate. Then they say, you see, then Democrats say, you see, everything's the same. You see, Biden, with Hunter, Hunter got the charge for the firearm. And it's like, first of all, Biden, had he protected his son, I would actually give him kudos and say, that's fantastic. Don't throw your son. Don't make an example of your own son. Hunter should be livid, which is the reality. He should be livid. If Biden actually protected Hunter, I would actually say, you know what? That's a pretty good thing. Maybe in a weird way he did with the laptop, but the laptop implicates Joe. So Joe was protecting himself. But the thing is, like, there was no statute of limitations for a misdemeanor with Hunter. These are federal crimes. With Trump, they desperately tried to imprison him with statute of limitations, elevated to a felony with a non-existent federal crime. With Hunter, federal crime, obvious. It's like, you don't have to convict Trump if convicting a Democrat is actually warranted. We don't live in a moral universe where everything that happens to Democrats must happen to Trump, or vice versa. The issue is who committed a crime. Trump obviously did not. Hunter obviously did. Joe and others obviously did. Hillary, what she did was an obvious crime. Maybe what Joe Biden did was even worse. At least Clinton illegally transferred top secret intel onto servers, which is completely impossible from a cybersecurity perspective. The Honorable James Comey never explained from a cybersecurity perspective how classified data, top secret special access program, was put on private servers. It's impossible to do. It's obviously illegal. But Hillary might have gotten tacit approval from President Obama. Also an illegal, that would also have been illegal. But you'd have to be stupid not to even ask these questions or even ponder any of this. You'd have to be a complete ideologue to just go along, to get along with all this nonsense. But with Trump, statute of limitations, it's like alchemy. They're like trying to create like this potion with the statute of limitations, and then what we'll do, yeah, that's the ticket. There's the FEC crime. Michael Cohen is stormy, but the FEC dropped the case, genius. Well, the jury and the court convicted. It's about the rule of law. Well, it'll be overturned. Trump won't need a pardon. He won't need a pardon. It'll be overturned by the appeals court or definitely by the Supreme Court whenever it gets to it. That's why it's just so funny the Democrats are going after the Supreme Court. Everyone loves the Supreme Court. Even, like, there's more Democrats that admire the Supreme Court, even with the conservative majority, than there are people who don't like the Supreme Court. Oh, maybe it's 50-50 with Democrats. Who knows? Maybe it's 40-60. I don't know. Anyway, hit subscribe if you're new.
When it comes to federal election campaign law, let alone seize the authority from federal courts and the Supreme Court to make these decisions, regardless of what the New York courts say up and down the chain. I mean, whatever the New York courts say up and down the chain, that is not the final decision. If the federal Supreme Court decides to step in, that's the final decision for you, New York. So if I'm in California and I see that it worked in New York because we have this lumbering appellate process, but I can interfere with an election. By the time the appellate process catches up with me, so be it. They're going to time it the same way. So this can really become a cancer on the political campaign system of the highest federal official in the United States, and the election there too. No,
Mark, I appreciate what you said in your opening statement, because the Supreme Court has made clear, not just in one offside comment, in 3 very clear decisions, that only the federal government can enforce federal law. Only the Justice Department and the Federal Election Commission can prosecute and bring suit for violations of federal election law. They're the guardians of how federal election should run. And so what happened here is that
only the federal government can level a statute against Trump. Falvey and Rob, thank you. I think it's going to be Hillary. Thank you, Falvey. I think Hillary, no chance for that gentleman, I don't think. I think Hillary Clinton somehow, some way. I think Hillary Clinton. You know what? They're going to pass the baton and she's going to say, me? You want me? I don't really want to, but the whole time it was, oh my God. Falvey, thank you. Rob, thank you.
That the DA, approved by this Judge Merchan, grabbed the authority away and basically decided to prosecute his own interpretation of federal law. That's not permissible under our separation of powers and federalism, and the Supreme Court will reverse if, as you say, Mark, they get a chance to hear this case.
When we come back, John Yoo, that is my question. So should we sit on our hands say there's nothing we can do, let it all work its way through the courts in New York?
No, I agree with Mark Levin. They have to. And this is all over the news, ladies and gentlemen. They have to get to the Supreme Court. And the Supreme Court will overturn it. It's just a matter of when. That's why I'm telling you. It's like it would be the equivalent of asking the Supreme Court justices to look up into the sky and say, is the sky blue? I don't need to guess whether or not they'll say the sky is blue. They all know the sky is blue. It's just a matter of when they're asked to rule on this. This is Bradley Smith saying there is absolutely no campaign finance law violation. And this is so important. This is exactly what John Yoo and Mark Levin are saying. It's been what I've been saying for about 3 weeks now.
Trump's indictment looks like a perversion of campaign finance laws. There are no crimes committed, or at least that's what Bradley Smith, Capital University law professor, chairman, and founder of the Institute for Free Speech. Mr. Smith is a former FEC commissioner, and he's the co-author of Voting Rights and Election Law. Brad, you're writing in the Wall Street Journal. We've been trying to get our paws on you for the show. Thank you for coming on. You're saying there was no crime.
My pleasure.
There was no crime to start with. Even if there were some issues on the so-called filing of business papers, there was still no crime.
Right. I've had a bit more time. I had the commercial break to look at the indictment a bit more. And it looks like the last couple pages of the indictment do intend to say that the crime was not disclosing campaign contributions, although they never cite a specific government statute. But here's the problem here. The prosecutor's theory goes like this. Federal law says it's a campaign contribution to make an expenditure for the purpose of influencing a federal election. Those are the key words, for the purpose of influencing. And he says, well, these payments were intended to keep her quiet, which would help the campaign, so they were for the purpose of influencing the campaign. Now, first, these payments could have been made for other reasons, right? To prevent embarrassment to his family, to preserve marital harmony, all kinds of things. But none of that really matters, because the standard here for the purpose of influencing is not a subjective standard, it's an objective one. So if I go out and I want to pay for TV ads that say, you know, Donald Trump is a ding-dong daddy from Dumas Bay, because I think that's really going to help him win re-election, it doesn't matter. Legally, that will not be for the purpose of influencing an election, no matter what my own subjective purpose was, right? It's subjective. So what counts as campaign expenditures? Things like, you don't hire a campaign manager unless you're running for office. Right. You don't take out ads saying vote for me unless you're running for office. You don't hire or establish field offices unless you're running for office. But other things you do. For example, you buy clothes whether you're running for office or not. So the fact that I'm running for office and I say, I've got to look good, and I go out and I buy a $6,000 suit that I would never otherwise buy, doesn't make it a campaign expenditure. It doesn't count. Same if I say I need a $600 haircut. Or to take a more perhaps relevant example, suppose I'm a business owner and I say I'm going to run for office, and I go to my corporate lawyer and I say, there's some lawsuits against our corporation. I think they're bogus, but let's get rid of them so they don't interfere with my run. Just settle those lawsuits. You can't settle those with campaign funds. It's not a campaign expense, even though that person's subjective purpose was to influence the campaign.
By the way,
so that's a very important part of the law.
I know. I was very impressed with the $6,000 suit. That must have been a custom bespoke suit. In your op-ed piece, it was $4,000. But I know we've had an inflation problem in the last couple of weeks. But your point here, I'm just having some fun. But your point here, Brad, if I understand it, is that you buy a suit, you get a nice haircut, whatever. You're doing it directly for the campaign. Is that correct? That's the point you're making. But if you want to
the point is, yeah.
If you want to defend yourself, your honor, keep it away from your wife, that kind of thing, which, by the way, is unproven. I mean, Stormy Daniels keeps telling people she didn't have an affair. Nobody wants to listen to her, but that's perhaps grist for another segment. But if that does not qualify because it's not directly for the campaign. Is that right? Is that my correct interpretation?
It actually goes further than that. Even though you bought that suit because you were running for office and want it to look good, it's still not a campaign expenditure.
Oh.
Why? Because you buy clothes. You buy clothes whether you're running for office or not, right? And so anything that people might do, even if they're not running for office, doesn't count. So people pay money. For example, they pay divorce attorneys to try to seal up their divorce records so that those don't become an embarrassment of the campaign.
Right.
Their purpose may be to influence the campaign, but it's an expenditure that somebody who wasn't running for office might also make. The only things that count are things that come directly out of the fact that you're campaigning. And the flip side of this is that it's actually illegal to convert your campaign funds then to personal use.
That's why the Steele dossier warranted a fine by the FEC. The only people fined by the federal government for breaking campaign finance laws were Democrats. That's why the FEC fined Hillary Clinton's campaign and the Democratic National Committee.
So it's actually illegal to use your campaign funds to buy that suit. It's illegal to use your campaign funds to pay a lawyer to seal your divorce records because you think that will help your campaign. And this is the real problem you have here. Not only is there, I think, not a campaign finance violation, this underlying alleged violation, but it's a situation where they're going to get Trump coming or going, because I think, knowing Bragg, and you've set the political stage very well, had Trump paid for this with campaign funds, I think we can feel pretty certain that he would be being charged today with having illegally converted his campaign funds to personal use. In other words, they were going to get him coming or going. If he pays for it with campaign funds, they were going to say it was illegal personal use. If he doesn't pay this money with campaign funds, which was the reality, now they say, oh, well, he should have used campaign funds. And that's, you know, the antithesis of the rule of law, where you set up a system where no matter what course of action a person takes, they're going to be held in violation of the law.
Well, I mean, but how does that get up to the Federal Election Commission?
This is the most important minute, 2 minutes on the internet with Bradley Smith and Kudlow and Fox Business right here.
Which has already turned this case down once.
Right. Well, this raises yet another question. Can, of course, a state prosecutor prosecute an alleged, quote, federal crime that the Federal Election Commission and the Department of Justice have already decided not to prosecute? We might think about it this way. Imagine if New York just passed a law saying it is a violation of the New York Penal Code to violate any federal law. And then we'll decide what federal law is violated, right? That would subvert the entire federal state structure of law. I mean, that would allow state DAs to start prosecuting anything they think is a violation of federal law, even though the federal courts or federal administrative agencies or the Department of Justice had thought it was not a violation of federal law.
John Yoo, Mark Levin, I've been saying the same thing from day one. Can't prosecute Trump. It's blatantly unconstitutional. It's really interesting. Like, everyone knows this, but it's not a national conversation. It's not a national conversation because people are almost asleep at the wheel in a way in so many levels. And people are trying to just Biden's economy stinks. Foreign policy is a catastrophe. We're trying to make it through the Biden age of Biden, the age of mashed potato. I used to say the age of Trump. This is the age of mashed potato brains. And I just don't think there should be a national conversation about this. I'm trying my best, as you know, in my humble way on my channel, but a state cannot level federal charges at a person. This is like basic knowledge.
So it's really getting into sort of wacky. That would subvert the entire penal code to prosecutor.
Get up to the Federal Election Commission, which has already turned this case down once.
Right. Well, this raises yet another question. Can, of course, a state prosecutor prosecute an alleged, quote, federal crime that the Federal Election Commission and the Department of Justice have already decided not to prosecute? We might think about it this way. Imagine if New York just passed a law saying it is a violation of the New York Penal Code to violate any federal law. And then we'll decide what federal law is violated, right? That would subvert the entire federal state structure of law. I mean, that would allow state DAs to start prosecuting anything they think is a violation of federal law, even though the federal courts or federal administrative agencies or the Department of Justice had thought it was not a violation of federal law. So it's really getting into sort of wacky legal theories, but also I think very dangerous theories. Again, if we think about the rule of law, I don't think this can be emphasized enough that if Trump had paid for these with campaign funds, which the DAs DOJ says he had to have done, I think they'd probably be chasing him today for illegal conversion of campaign funds to pay this personal expense.
We don't know.
So there you go, ladies and gentlemen. There you go. This is Alina Habba talking about the Supreme Court.
Saying this is just, a thing, to get the statement out there. Trump's a convicted felon because they know they're going to get it overturned on appeal.
Right.
I mean, Harvey Weinstein's conviction was overturned by the New York Appeals Court, but that wasn't until 4 years later. Do you guys plan to go to as high as the Supreme Court?
If we have to, we will. We have no problem with that. As you know, we've taken those matters that we think are incredibly important to validating and preserving the Constitution that our country was made on. There were incredible constitutional violations in this whole proceeding, including the current gag order that's on me, the president, and anybody that works for him. It's crazy. So, look, if we care about America, we have to fight for it. And his legal team is prepared to do so in whatever way we need to do.
Show what Ellie Honig said.
Falvey Pollard, thank you. Yes, I mean, just what, today? They're going to hold Merrick Garland in contempt of Congress. We'll see how that goes. But yeah, I mean, look, Trump has to behave in a reciprocal manner. What they did to him, he has to do. This is the great Alan Dershowitz right now.
Rigged. In my book, Get Trump, I predicted months before this case ever came to trial that it was a foregone conclusion there'd be a conviction. A biased judge, a biased jury, a biased prosecutor, a man who ran for office on the theory of let's find the crime to prosecute Trump for, and they couldn't find the crime, so they made it up. We're now a day after the verdict. I've known criminal law. I've been involved in criminal law 60 years. I still don't know what the crime is.
Right.
Was he?
This is what, the fifth, sixth legal scholar? Nobody knows what the crime is. Nobody knows what the federal crime is. And furthermore, the state of New York does not have the right to level a federal crime at Trump.
Found guilty of intending to violate tax laws, to violate the federal election laws, to defraud the voters. I still don't know. And we're a day after this. This is the most outrageous case. Everybody knows the quote from Lavrentiy Beria, the head of the KGB, and Stalin, when Beria said to Stalin,
show me the man and I'll show you the crime.
No, find you the crime.
Find you the crime, yeah.
Tried to find the crime, and he couldn't. So he made up the crime. He took it a step further than Stalin and Lavrentiy Beria. This case will go down in history as one of the most abusive prosecutions since the trial of Aaron Burr back in 18 whatever. This is a stain on our criminal justice
really is.
system.
And by the way, you're not the only liberal Democrat saying that. We had this interesting piece that was in the New York Magazine, of all places, by a CNN analyst, Ellie Honig. I don't know if you saw it, came out this morning. He says the charges against Trump are obscure and nearly entirely unprecedented. In fact, as you say, made up. No state prosecutor in New York or Wyoming or anywhere has ever charged federal election laws as a direct or predicate state crime against anyone for anything. None ever. So you're not the only liberal Democrat who believes that. I just wonder how many other folks out there who used to be against Trump are now in his favor. People are allowed to be inconsistent, but the judge is supposed to keep prejudice out of the courtroom. And his instructions to the jury, I've never seen anything like it. Somebody just called it a roadmap to conviction, which is essentially what it was. The judge is supposed to be neutral, if anything, on the side of the defense, because it's the prosecution that has to prove
that something has been done illegally. But in this case, he was providing the jury with a road to conviction, was he not?
Yes. In fact, the day before the conviction, I wrote a column saying this was a directed verdict by the judge, that the judge was directing the jury to convict. And by the way, he didn't have to. The jury would have convicted anyway. Once the jury was selected from New York voters, 85% of whom don't want to see Trump as their president, the die was cast.
Crimes. Nor is paying money under an NDA.
So again, he was convicted of things that weren't crimes.
Of course he was. Not only that, but the federal government manipulated the plea of Cohen to include Trump precisely in order to get this kind of argument that could be made. But it's pure hearsay. I mean, if Cohen thinks that Trump is guilty and pleaded guilty to a crime involving Trump, that's not relevant. So this case should easily be reversed based on the New York Court of Appeals decision in the Harvey Weinstein case. But because this guy's name is Trump, it's even worse than Harvey Weinstein in the view of judges. And so I'm not confident.
So, ladies and gentlemen, be here at 10 p.m. Eastern tonight. I will have another live stream. I'm not confident the appeals court's going to overturn anything, although they should, and they should. I'm just not confident in the timeline. The Supreme Court, I'm certain, will overturn it. Democrats have two enemies, Trump and the United States Supreme Court. That should tell you something about which side of history that you're on. Give me your thoughts below. Hit subscribe to my super